Hi, this is Lisa Gale. I'm happy to present the NAR Commission lawsuit for Vermont Realtors, courtesy of Fidelity, National Title Company. Today we have speakers from Fidelity, Charles Cain, and panelists Dave Raphael from Artisan Realty and Kate Taylor from Gale Legal Group. I try to put on an annual in-person seminar once a year and look for topics that benefit specifically you guys, and we feel like you're the heart of our real estate team. You're the quarterbacks that pull it all together. So I hope you find this helpful. I'm always open for topic ideas and discussions beyond the annual one. We come into your offices, we do trainings. We are happy to do that in any way. As teamwork is instrumental in putting together anything, the seminar came together in record speed from an idea maybe a month ago at the board meeting that we needed some NAR training that wasn't just information that had nothing to do with Vermont. So I'd like to take a moment and acknowledge the people that have made this possible today. First thing was we needed a keynote speaker. I called my friend Peter Zook at Fidelity National Title Insurance and said, can you find me an expert? And in 24 hours, he found us Charles Cain. So in addition to that, Peter set up a recording of this presentation today, so it'll be available for other realtors who weren't able to be here, and Troy will be making that available later. So if you miss anything, you'll get a second shot at it. So thank you to Peter for making this happen, Fidelity National Title, and Charles from traveling here from, I'm not even sure today where you came from, but.
Well, this week Jackson, Mississippi,
okay.
but I'm from Cincinnati.
He's traveling all over the place doing these. So I just want to take a moment to introduce Chuck Cain. He has been in the title insurance industry since 1977. He's a graduate of Ohio State University, go Buckeyes, and the Salmon Chase College of Law at Northern Kentucky University. So he is an attorney too, so don't hold that against him, but he spent a lot of his time traveling, talking about this and so many other topics. So I feel like he is got his finger on the pulse and was still providing updates to this material as of yesterday, and we will probably still be getting updates of this material as we go forward into the months because we still aren't at the end of this process.
Thank you very much, and thank you, Lisa and Gale Legal for putting this on. We've been talking about it for a couple of months, and in those couple of months, just a few things have changed from what we thought was going on back in early April, and as far as being an expert, I am from more than 50 miles away, therefore I'm an expert. My presentation, I want to talk about sort of the nuts and bolts of the realities as far as we know them to be. And then in our second part of it, David and Kate, we're going to talk about more into the weeds about what goes on here in Vermont. They are far more knowledgeable than I am as far as the practice here in Vermont. So especially in regard to questions that are beyond the scope of sort of the legalities of what I'm going to be talking about, you might want to save those for the second part because frankly, I may not be able to answer those questions. All that being said, and by way of sort of preface and history, and as Lisa mentioned, I've been in the title and settlement business since 1977. Carter was the president then. Some of you may not know there was a president named Carter. The first loan I closed as an attorney was a VA loan. It was a 16.5% interest rate, and the seller had to pay 4 points to get that rate. So when people talk about, oh my God, there's going to be 7%, I'm not afraid. We've seen these trends, we've seen these marketplaces change, and we shall endeavor to persevere through all of these things. But by way of sort of background about the commission lawsuit, and again, by virtue of age, one gets perspective. The Department of Justice has been chasing around the National Association of Realtors for 30 years. I was with Steve Murray, the founder and president of RealTrends, back in March, and Steve was talking about how he had been an expert witness in regard to an investigation launched by the DOJ in regard to the National Association in 1993. He said it has been going on that long. And, and it comes and goes in various routes through that period of time. But it doesn't seem to be tied to any political administration necessarily. For those of you who remember, back and were in the industry back in 08 and 09, in the 2 previous years, the U.S. economy, generally speaking, was in a recession. The one thing that was keeping us out of an overall recession was real estate. That people were buying homes, and we were doing our work. When I say we, everybody in the real estate industry, in realty, in lending, title and settlement, was doing their best to keep things going. Then when the economy collapsed, not only had we been keeping the economy going, but then of course we were blamed for the collapse of the economy. How dare we? And of course, having been through the COVID years here, in regard to what real estate professionals, what lenders, and what title and settlement did to keep what was arguably the largest real estate market going in the history of the United States. Once we got through all of that and had been at least minor heroes, then of course they turned on us like angry tigers that, well, we're really charging too much. And how dare we, because aren't we the impediment? And I say we, all of us, aren't we the impediment to home ownership in the United States? I don't think there's anyone here in this room who believes that story, and that belief is well grounded. There are many people who seem to think that anything that generates a fee for someone has no value. But the fact of the matter is, the fees in our industry, almost all of them have very high value, especially for first-time home buyers. So with that being said, so how big is the real estate industry? And most of you probably know some of this data. But according to NAR, the membership, the number in 2022 is about 1.6 million active real estate agents in the United States, with as many as 3 million licensed agents. And the vast majority of licensed real estate agents throughout the United States are people who, by and large, don't really sell real estate. A lot of them are rental agents. They have the licenses for various purposes. So that's something that's quite often lost if you read the New York Times or the Washington Post or the Wall Street Journal about how big is the industry, because the majority of people who have real estate licenses really don't sell real estate. They do other things with those licenses because perhaps by state law or by custom, they need to have those things. So in 2012, there are about 1 million active agents. So obviously the head count has grown considerably as the market generally turned up and as more and more people decided to get into the real estate industry to make a good living. I think too, and again, this is NAR data, the typical realtor, and we should all be reminded that realtor is a copyrighted term. For some reason, my PowerPoint wouldn't let me put the little C on there. But say David's been involved with NAR for some time, and I know that when I've done presentations to the executive committee at NAR, they always point out, it's like, now remember, it's copyrighted. It's like, okay, thank you very much. So again, if you're not a member of NAR or a state affiliation that entitles you to do it, the term realtor is a copyrighted term. It is not a term of art. So from that standpoint, someone who is not a member really cannot use the term realtor. The typical realtor is a 56-year-old white female who attended college as a homeowner. That's sort of that statistical number. Brokerages, about 107,000 real estate brokerages. Again, this is NAR data. And this NAR data is probably 5 or 6 months old at this point in time, so these numbers may have changed. We have seen an awful lot of brokerages around the country, especially in the last 90 days, having been sold. And a lot of those are brokerages that have worked heavily in significant metros with buyer side representation, where perhaps 60 to 70% of the sides that they do are buyer sides. And they are concerned about how revenue streams are going to flow, as we're going to talk about here. in the upcoming couple hours. Most are small, with the median closing about 3 transactions per month. So if you're hitting that, you're average. That's very common, especially when you get into rural areas throughout the United States. I was in Texas here about a month ago, and in Texas, that number is true in Texas, even though Texas, when you're talking about Dallas, Fort Worth, Houston, San Antonio, Austin, these are huge major metros, and Texas really is, in all effects, an urban state at this point in time. But there are 3 million people who live in Texas in rural areas. So again, that's who services areas like that. But the typical real estate broker is a 49-year-old white male who attended college and is a homeowner. So a little distinction there about who's out selling real estate, who is in fact a brokerage owner. But the NAR lawsuits, and there are, as I recall now, 24 federally filed lawsuits involving the National Association of Realtors, multiple listing services, and various real estate brokerages from around the country. There are, at last count that I saw, 62 actions filed in state courts in regard to the issues that were raised in the Sitzer Burnet lawsuit. The Sitzer Burnet lawsuit, a federal case filed in the Western District of Missouri. It was filed in 2019. In fact, it took a little over 4 years to come to trial. So it was, before COVID, if anyone can remember, before COVID. Went on for some time. It was then a 2-week trial. The verdict was rendered on Halloween, perhaps not inappropriately. These lawsuits allege that the National Association of Realtors, along with some real estate companies, violated federal antitrust law by conspiring to require home sellers to pay the broker representing the buyer and thus pay an inflated commission. That's sort of the nuts and bolts of what this is about. In the Sitzer Burnet lawsuit, the plaintiffs were sellers of real estate, people who had sold real estate in the state of Missouri for the previous 10 years was the certified class. The verdict that came out in regard to the Sitzer Burnet case, $1.6 billion was the initial verdict, which could be treble damaged under the federal statute. Since then, there have been settlement agreements by all the parties in the Sitzer Burnet case. We'll talk about where that takes us likewise. But based on the settlement numbers, just to give an idea, and class action attorneys sometimes get a bad reputation. I don't know why. But only because if you've been involved in any organized business at any point, you've probably had some class action that's impacted you. But after the attorney fees are paid that have been submitted to the court, that group of plaintiffs, again, everyone who sold a house and used a real estate professional in Missouri for 10 years, that final verdict, each of those plaintiffs will realize about 45 cents out of the settlement agreement. So this is not so much about the damages to the individuals in the suits. And again, it's sellers in Sitzer Burnet. In many of the other lawsuits, it's buyers who are the class. And we were talking about it last night and here this morning. What this all focuses on is transparency. And what do people know, and what did they believe, and what did they understand when they went to either list their house or they went to buy a house? Again, 24 other such lawsuits in federal courts. So this is still roaming on. The Sitzer Burnet case is, again, the most famous. It's the one that's made all the papers. If you read the trade publications, it will give you a better idea as to what it really means. But if you read Wall Street Journal, New York Times, the Washington Post, the headlines are buyers no longer have to pay a real estate commission. It's going to save billions of dollars, and that this is something that's simply in the past. We all know that to not be the case. The National Association of Realtors has data going back now well before COVID that the vast majority of people looking to buy a house want to use the services of a real estate professional. It's not an easy process. We all know that. There's a lot of moving parts. There's a lot of people involved. So people do want to use real estate professionals. How everybody gets paid and by whom, that's where we're all going forward. So, what does it center around? Well, the cooperative compensation rule. And again, this is something that I'm sure all of you are aware, but it's a mandatory rule of the National Association that requires all listing brokers to make a blanket, non-negotiable offer of buyer-broker compensation when listing a property on a multiple listing service. And it's been a rule for years. It's been a practice since the Korean War. So this is something that has gone on for a very long time. And not surprising, and some data that NAR came up with a couple years ago in which they weren't real pleased was entered into the trial at Sitzer Burnet, is that, and this is I'm sure a big surprise, that where there is an offer to a buyer, agent, buyer, broker for a commission rate of 2% or higher, those houses sell 3 times faster. Now, there's a lot of arguments as to why, as to the nature of those homes, but that was data that was thrown out some time ago. As far as that, if you offer something to someone to sell a house, that it's going to sell a little faster. Well, I think being capitalist, we sort of get an idea as to what that's about. If there is a fee that's going to be paid, that and again, a blanket, non-negotiable offer. It's like, here's what it is. So in exchange for this access, NAR required sellers who list on an MLS to also agree that the seller will pay a commission to the buyer's agent or broker. So again, this was the requirement in terms of the synopsis. So in the trial, NAR argued, well, this number, it could be 0. It's not that you have to offer something per se. Yes, you do have to have a number in there, but it could be 0. It's not necessarily that the seller has agreed to pay anything in regard to commission. And what we have seen as far as sort of a transition in the marketplace, Redfin reported that in the 4th quarter of last year, that within Redfin, about 8% of sellers either wanted to negotiate or not pay a buyer agent, buyer broker in regard to the showing of a house. So 8% in the 4th quarter. Again, the verdict came out on Halloween, made a lot of noise in the public press. Redfin said in the 1st quarter of this year, the number went from 8% to 29% nationally. Again, people read the papers. They, I say read the papers online. I still talk about papers. But I still occasionally go like, oh yeah, call me. It's like, no, it doesn't look like that. But so there certainly has been this belief, this sea change in the marketplace. It's not everywhere. It's not everybody. But the questions are now arising. And I think if you think about it practically, and someone who mentioned this to me, no less person than Brad Inman from Inman Connect, and I'm sure probably many of you are aware of Inman Connect and all the things that they do in terms of assisting real estate professionals. But as Brad Inman said to me, he said, when I sold my house in West Hollywood, I sold it for just under $4 million. And he said, at the time, and how he eventually sold the house is a whole nother story. But he said, in the initial listing, he said, and I asked, again, I'm in a seller's market, even at $4 million. Why am I paying $120,000 to a buyer agent who probably is, all they're going to do is walk through this place? They're probably not going to do very much. And so when you're talking about those types of home prices, that certainly becomes a question, especially if it's an experienced seller, that they're going to think about. It's like, well, I've sold 5 houses. I don't know and say in this market. Now, we change to a buyer's market and everything changes. You know, a lot of these things that are being put forward out of this verdict is based off the way things are today. All of us who have been in this industry know that today is a very short period of time. It may only be this morning in terms of how the marketplace changes. We could rapidly move to a buyer's market here in the near future, and that may change a lot of dynamics here. But all that being said, talking about the proposed settlement agreement, and NAR and the other defendants in the Sitzer Burnet suit have proposed settlement agreements. Anywhere, Keller Williams and RE/MAX offers were approved by the court preliminarily on May 3rd. The NAR settlement has also been preliminarily approved with a final approval expected in November, so right around Thanksgiving. And BHHS Home Services, their settlement offer was made later, but not yet approved. So the Judge Bowe in this case, is inclined to take these settlement offers. That being said, in the last week, 3 of the plaintiffs in the Sitzer Burnet suit have said, we don't like these settlement offers, and we object to the settlement offers. We'll see if that bears any fruit with the judge. Most of the people I know who are engaged or follow the litigation very closely think that he is probably going to take these settlement offers, if nothing else, to get this off his desk and let it move forward. And then if they want to appeal the settlement offers to the Court of Appeals, good luck, because in the Federal Court of Appeals, settlement offers are rarely overturned unless they're unconscionable. So probably, and again, probably is the word here, we'll see these settlement agreements that have been put forward in Sitzer Burnet accepted and probably ratified here by the November date. Also, too, Douglas Elliman, Realty One Group, At World Properties, and the Real Brokerage also have submitted settlement agreements in regard to Sitzer Burnet and some other litigation that they're involved in. So pretty much the numbers are being knocked down. People are coming to this because, again, $1.6 billion, that's a little bit more pocket change than even NAR has or could raise. And the cost of litigation is huge. Cost of litigation is in the tens of millions of dollars for many of these defendants. So to drag this out is probably in no one's interest. And dare I say, the plaintiffs' counsel, they are happy with the settlement agreements. That means they get paid faster. So how much? Again, NAR settled for $418 million. It's payable over 4 years with interest in 4 annual installments. Anywhere and RE/MAX were the first ones to come to the table. They came to the table before the actual trial. And their settlement, $83.5 million for Anywhere, $55 million for RE/MAX. Keller Williams came to the table after trial. They were initially going to appeal, $70 million. Berkshire Hathaway Home Services were the last ones to come in. And if there's anything that shows here, and as most attorneys know, the last person to offer settlement doesn't get the best deal. $250 million is what BHHS has offered. But again, far less than the $1.78 billion verdict, which could become almost $5.4 billion in regard to the treble damages available under the statute. Pardon me. So who does it apply to in regard to the settlement agreement? Well, it applies to the organization, to the National Association of Realtors. It also applies to NAR members. It also applies to all state and territorial realtor associations, also all association-owned MLSs, and all brokerages with a NAR member as principal that had a residential transaction volume in 2022 of $2 billion or below. So smaller real estate brokerages are covered by the settlement agreement. If, though, that total transaction volume is over $2 billion, that's a separate issue, and we'll talk about that as to how can a company that has that perhaps participate in the settlement agreement. Again, what about $2 billion and above? Well, again, the NAR settlement agreement creates a framework for firms to opt in. So you have over $2 billion in total transaction volume. That's the sale price of the properties. So $1 million house, it's $1 million to total transaction volume. Now, that being said, again, one of the entities that has always been chasing around the real estate industry is the Federal Trade Commission. Generally speaking, and say both David and Kate are not as knowledgeable about this or more so than I am, but if you sell $1 million house and you represent one side, well, the old FTC rules that rolled out in the 90s said you can claim $500,000 towards your volume. If you sell both sides through the same brokerage, and in 41 states, that is allowable to be done. Vermont does not have dual agency, but the majority of states have dual agency either by brokerage or by the individual agent who can represent both sides. But if you sell both sides, you can count the $1 million. There have been brokerages in the past who, shall I say, have chosen to inflate their numbers, to look bigger than they were. What a mistake that now appears to be. And what it would require is the settlement would require depositing into escrow an amount equal to 25 thousandths multiplied by its average total transaction volume over the most recent 4 calendar years. So that includes 2020, 2021, and to be bound by the terms of the settlement. So what does that number look like? Well, if there is an entity that has, say, $3 billion in total transaction volume, that comes to about $1.75 million. That's a lot of money for any real estate brokerage. Again, independent MLSs can opt in with payment being 100 multiplied by their 2023 subscribers. So again, any independent multiple listing service can opt in, but that's their formula. So this can be likewise in the hundreds of thousands of dollars for smaller multiple listing services in order to opt in to the settlement. Notable practice changes as a result of the settlement. And we'll talk about it in the second hour here, because as we were talking about it last night at dinner and then this morning, the way business has worked in Vermont is not terribly different from what the settlement agreement calls for to be done in most of the rest of the country. Steve Murray at Real Trends running a poll with various brokerages in the United States, 72% of agents or brokers representing buyers never got any type of written agreement in regard to that commission. In where I am, in Southwest Ohio, Northern Kentucky, Southeast Indiana, to see a buyer's agent agreement was like seeing hen's teeth. I mean, you rarely ever saw it. They simply relied on what was in the MLS, and they never brought it up, which again, this is a lot of the argument, the transparency, to explain to the sellers and buyers, how does this work? We have X percentage commission. Where does that money go? What does it do? We have in our industry, unfortunately, and say in my industry of title and settlement, we are perhaps more guilty than any other aspect of the real estate industry in explaining our value proposition. What do we do? Peter and I were talking about it this morning, and you've probably all seen them, but for years the National Association of Realtors would run commercials on television. And it was always, call a realtor. I always found those commercials, even when they were running, to be objectionable. Because usually the commercials I saw was some usually very attractive blonde female real estate agent showing what appears to be a house in Southern California by virtue of what the weather looks like, to an appropriately diverse young couple. And everybody's smiling, and everybody's happy, and everything is working just beautifully. What I always thought they should have is, show that real estate agent who at midnight on the weekend is in the basement of a house knee-deep in muck, because their sellers have moved on and there's no one else to let the plumber in to get the sewage out of the basement. Show that. That's the value proposition. Doesn't happen every day, but it happens enough. And so I don't think the association did a great job in regard to that. And part of the function of those commercials, quite frankly, was recruiting, is what I've been told by several people at NAR. It's like to get more people into the industry. But again, noticeable practice changes. The cooperative compensation rule is gone. And there's a prohibition that any offers be blanket, unconditional, and unilateral. Everything is open for negotiation. It prohibits making offers of compensation on the MLS to cooperating brokers or disclosing on the MLS listing broker compensation or total broker compensation. And NAR said they're looking for an implementation date of August 17th to accomplish this. So in essence, that you can't show on the MLS what the offering is. It can't be done. It's prohibited to do it on the MLS. Buyer agreements. MLS participants working with the buyer must enter into a written agreement before the buyer tours a home. And we'll talk about what tour means. English is a great language because words have many uses. But we'll talk about that in the second hour. But what needs to be done is that the agreement has to specify and conspicuously disclose the amount or rate of compensation received or how it is determined. If it's a percentage, if it's flat dollars, whatever that number is, the amount must be objectively ascertainable. It can't be open-ended like, well, whatever the seller is offering. It has to be X. It has to be something so the buyers understand what that number is. Because again, it may be that the buyer is going to pay that commission. We'll see. In some marketplaces, that is happening. In some places, not so much. And can't be paid compensation for brokerage services from any source that exceeds the amount or the rate agreed to. So you can't say, well, we have X percentage in commission, but then we have a representation fee. That's $1,000. No, you have to build all this in. And again, transparency. This was the problem, is that the argument of the plaintiff's counsel was that buyers and sellers didn't really understand what they were paying for and how much they were paying and to whom in regard to that. Also eliminates and prohibits any requirements conditioning participation in NAR MLSs on using the cooperative compensation rule, and agree not to create, facilitate, or support any non-MLS mechanism for listing brokers or sellers to make offers of compensation to cooperating brokers. A conversation that at the Housing Wire conference in April was that, and dare I say, not you in this room, because you're obviously concerned, you understand what the rules are. There are a lot of people out there who are still trying to find foxy ways around these things. And as one person said, well, maybe what we'll have in our community is we won't have a multiple listing service, we'll have a general listing service. And we'll get some of the brokers to participate in that. And so that won't be an MLS. And it's like, no, don't do it. It's a bad idea. You're going to be violating the terms of the settlement agreement because you can't go off and do this on the side. Now, independent companies, homes.com is an example, that's not covered by this. But if there is involvement by the realty community, that is something that is prohibited under the settlement agreement. And again, talking about it at the Housing Wire, last 2 weeks ago, I was in Texas, and the counsel for the Texas Association of Realtors said that an agent approached her and said, well, what I'm going to do is, because the MLS in the Dallas-Fort Worth area has all kinds of photos of the property. She said, I'm just going to include a photo. It'll be a picture of the bed, and on it will be an embroidered pillow that says we pay 2%. and like, no, you can't do that either. Okay, so it's and again at the Housing Aware Conference, someone who has been a real estate broker for 25 years in Arizona, and her comment was, well, if we really have a problem with this as far as the buyer agent being paid, I'm just going to tell my people to go out in the parking lot after the closing and write them a check. And it's like, well, that not only violates this agreement, it also is what we call loan fraud. So again, to be tied to this, and again, here in Vermont, I don't think the changes are going to be hugely dramatic. We'll talk about it and answer your questions here in the second hour. But still more, it requires NAR MLS participants acting for sellers to conspicuously disclose to sellers and obtain their approval for any payment or offer of payment made by listing broker or seller or seller to buyer's broker. So the sellers have to understand in regard to this as to what is being paid by whom, to whom, and is the seller in fact going to be offering something that they're going to agree to pay. Require MLS participants to disclose to prospective buyers and sellers that broker commissions are not set by law and are negotiable. And I was in a closing many years ago where, back when we still had 7% commissions, a buyer turned to me and said, 7%, that just, it just seems a little high. But then I was told that that's the law in Ohio, that it's 7%. It was like, it's not the law, but that was what their real estate agent had told them. But cooperative commission is not banned. So that's to say it can still be provided for. It's just how it's communicated, and again, the transparency. What do the buyers and sellers know? Has it been disclosed to them? Do they have an understanding about how all this money is going to flow? You just can't do it through the MLS. Seller concessions may still be offered through the MLS, so long as such concessions are not limited to or conditioned on the use of or payment to a buyer broker. So concessions can still be in the MLS, and again, pursuant to the proposed settlement agreement. We are still in a state of flux with all of this. There are still clouds of unknowing as to where we will be a year from now. Could Judge Bowe say, well, we're going to throw out the settlement agreements? Again, I don't think so, but it could, which means we're back to square one, and we have all this other litigation still going on. In some of the litigation, in some of these federal districts, especially the Fifth Circuit in Texas, NAR might win if they continue in this litigation. They might win one of these, and then we have what is known as a diversity of opinion from district to district or circuit to circuit. And we've had that before in real estate law, where half of the Court of Appeals circuits say, well, this is legal, and the other half say, no, it's not. We just saw that with the recent Supreme Court case involving the constitutional provision of the CFPB. The Fifth Circuit said, no, it's a violation of the Appropriations Clause, you can't do it. The Second Circuit said it's exactly within the Appropriations Clause, and it's why we think you can. It ended up in front of the Supreme Court, who 7-2 said, we agree with the Second Circuit. The CFPB is legally constituted as to how it's funded. So again, that does happen. Pardon me, but again, this is part of what has been put forward. The reactions by other players, the GSEs, Fannie and Freddie, will not count buyer agent costs in the cap on seller concessions. They jumped on that fairly quickly, especially because they are under extreme scrutiny and heat from the White House in particular about reducing the cost of home ownership. And so if seller concessions simply went out the window, that was going to be an unintended consequence. And I believe, just as a personal opinion, not reflecting any of the opinions of any of my fellow panelists who may share them, there are a lot of unintended consequences of this. The VA has for years prohibited veteran borrowers from paying any real estate commission, but Tuesday they decided to implement a, quote, temporary change There are temporary changes at the VA that have been in place since the mid-1990s. So when they say temporary, they mean it more in like geologic term frames. So probably we will see this continue with the VA. They were among the last ones, and FHA, again, will not count buyer agent costs in their cap up to 6%. So all of the entities, the GSEs, FHA, and VA, have said, okay, we're going to move forward with this based off of the reality of the situation. We do not want to create more problems in regard to people getting loans for home ownership. So, for title and settlement, and this slide is more for those of, say, in my industry, involving title and settlement. Will we see an expansion of dual agency? There are, again, 41 states that allow dual agency. 9 do not, and in 5 of those states, there's already initiation by the State Association of Realtors or by appropriate lobbying organizations to change that law and allow dual agency. Dual agency differs from state to state. Dual agency could be that you could use the same broker in some states where you have 2 different real estate agents in the same brokerage, and they create sort of a Chinese wall, as law firms have for years, where it's the same broker is allowable. But in many states, and say Ohio and Kentucky and Indiana, where I have worked for years, the same agent can represent both sides. And a good friend of mine does that all the time, has been doing it for 30 years. When I saw him in November, and he's very productive. He's top 1% of Coldwell Banker nationally. I saw him in November, and say, I don't know how it was in Vermont, but last autumn was sort of the bottom of the barrel in most marketplaces in terms of real estate sales. I said, Michael, how are you, what was November like? He said, well, I only sold 12 houses. I said, well, and he sells $900,000 as his average sale price. I said, well, the leading real estate agent in Tampa sold 12 houses, so you did pretty well. But I said, again, because I knew he did buyer sides as well as seller sides, how many of those did you have the buyer side? He said, oh, half of them. So I said, you had 18 sides in November. And he said, yeah. He said, it was a slow month. So in those states, and that is something that we're looking at in those states about how does that work, and real estate brokers are certainly looking at that as well. Because if you are principally a buyer brokerage, if you are principally a buyer team, will the revenue be there? And will there be a shift in some of the marketplaces as to who decides closing table? Will it be perhaps the listing side more than the buyer side in those markets where buyers agents and buyers brokers have tended to control the placement? Again, marketplaces are marketplaces. It can be very localized. What happens here in Burlington and what happens in Bennington may be very different as to how things move forward. But these are just some of the ideas and concepts. And the relocation industry is historically has generated revenue from being paid a portion of the buyer's brokerage commission. These people are in a panic because now suddenly their dollars are drying up. And are they going to have to turn to the employers, who typically they have actually returned dollars to for relocation, to ask for revenues? Likewise for the relocating parties. So they are terrified about what this may do to them. A potential impact on home affordability. Let's say the seller says, I'm not paying anything. The buyer wants to use the services of a real estate professional. Now that Rubicon has to be crossed. How are they going to pay for it? Do they have the money? And now, what cash on hand do they have? It's like, well, I can either pay my agent or buy the house because I don't have that much money. And I think the real impact here is going to be first-time home buyers and minorities. I think fair housing, this is going to be a big problem. Because if you're selling a house and say, where I come from, there's a lot of $140,000 houses that sell in impacted communities that are minority communities. So what happens to them? If it's like, no, I'm not going to pay a commission to your buyer's agent. This could further restrict home affordability. So again, unintended consequences and reduction in number of real estate agents already occurring because the market has slowed. How many more agents will be gone? Some analysts say as many as 70% of present buyer agents could be gone within 2 years. We'll see. One never knows. Moving forward, the U.S. Judicial Panel on Multi-District Litigation did not allow consolidation of the Sitzer Burnet settlements in 21 other pending federal cases in 9 federal courts. So those litigations will move forward. Now they're moving forward far more slowly because those courts want to see what works out here in terms of acceptance of the settlement. So a lot of those trials have been pushed back. Again, Sitzer Burnet was 4 years to get to trial. 2-week trial, verdict came back in 2 hours. 2-hour verdict, that means they didn't order lunch. That's a rare thing for a jury not to order lunch. They went in and chose a foreman and said, who thinks that there's a problem here? And they voted, and that was it, and they were back in the courtroom. Again, we'll see how this goes. And the U.S. District Court for the D.C. Circuit has allowed the Department of Justice to continue their own criminal investigation into alleged antitrust activity by NAR and MLS. The DOJ has advised they oppose commission offers being made anywhere, not just in MLS. That in a private showing, if you put on a banner behind an airplane and fly it over town, they believe it should not be offered anywhere. And as I mentioned in initial comments, Department of Justice, 30 years, they have had agreements, and they are still coming. Again, these investigations by the DOJ can involve civil remedies, could be criminal remedies. Do I think anybody's going to prison for this? I doubt that. That being said, it's more money, more money, more money. Title agent, I'll move forward through this, but one thing which I'll just say to sort of the bottom line here, affiliated business arrangements. I've been involved in affiliated business arrangements for 30 years. And we see affiliated business arrangements on title, on lending, proliferate. My phone has blown up, not just since the NAR MLS suit, but really since the spring of 2022. Because real estate brokerages, the question is, where's the revenue going to come from? And at the Housing Wire conference, I've been doing it for 30 years, and usually when people talk about, from the real estate industry, talk about having a title and settlement or lending affiliated business arrangement, the term always was these were ancillary services. Our core service is selling real estate. At that conference in April, the term core services included affiliated business arrangements by everybody. They said, well, what are you doing in terms of your core services? They meant title and settlement and lending, where again permissible and where it makes financial sense to do it. Because the revenue streams, where is the money going to come from? So ABAs, they are proliferating. There is no question about it. So that being said, I guess we can take a break at this point in time.
So Lisa, said I get to be Hope today, so I'll be Hope. So here's the good news for realtors in Vermont. We are already doing 90% of what the practice changes in the settlement agreement require, right? The only fundamental change for us in the state of Vermont is when we enter into those agreements, and we'll talk a little bit about what it means to tour a home, and then the fact that universal offers of compensation are going off the MLS. But other than those two things, we've always required written buyer agreements. We've always been required, both by our code of ethics and our licensing law, to talk about our compensation and how we get paid. So the conversations are just changing a little, but the requirements have always been there for us, and we're way ahead of the curve. There are parts of the country that don't have buyer representation agreements and don't require them, and we're not there. So if I can leave you with one thing today and one resource, it's go to facts.realtor. That is your site for everything settlement related, from practice changes to MLS policy changes to the timeline for the settlement agreement. The FAQs there's almost 100 of them, are updated continuously and will answer like 90% of the questions that were sent in, they're all there. There's also a great write-up on written buyer agreements and what should be contained. And the other thing I'd leave you with is your association, the Vermont Association of Realtors, is deep in the weeds. There are several members of the Forms Committee here, Carolyn's here. They're deep in the weeds at looking at what tweaks are going to be required to our either exclusive right to market or to our buyer rep agreements to make it a little easier to talk through those changes with your clients. We're never going to tell you how to practice, but we're going to give you the tools you need to practice. And even if we did nothing to those agreements, they contain everything that's already required in the settlement. We're just going to make it easier. So, good news.
Yep, I would absolutely echo everything that you just said. Coming from Massachusetts, 90% of realtors there don't use buyer representation agreements. So this happened and it was like the sky was falling. So you guys are a world ahead of a lot of your colleagues in other states with already having that be part of your practice. The only thing I would really add to emphasize as part of the settlement, you want to ensure that you're really sitting down and reviewing that contract with your clients rather than using your e-signature platform and just sending it off. You really need to sit down, have that conversation, ensure that they understand what that compensation is and how it's flowing through the transaction, and be able to explain that competently to them and be able to explain your value. One of the resources we were just talking about a couple of minutes ago, there's actually 2 documents. One is 179 ways and the other is 151 more ways, I think, and it literally outlines 300 different things that you do during the course of a transaction, and that can really help you when you're working on that value statement. You can even provide those documents to your clients and say, as a buyer's agent, we don't just open the door. These are all of the things that we do for you. This is how we earn our fee, and this is why our fee is worth being paid in the transaction. So Facts.Realtor is a really good resource. RealEstateCommissionFacts.com is also another link that NAR has created that is more consumer facing. So if you are faced with sellers or buyers that have questions about the lawsuit, what it means, how compensation works in a transaction, that's a good resource that you can point them to expand upon what you're able to share with them.
One thing, and I'll throw it out now, Winston Churchill used to tell the story about the Englishman who receives a telegram advising him that his mother-in-law has died while she was vacationing in Brazil, and the Brazilian authorities are asking about disposition of the body. And the Englishman cabled back, embalm her, cremate her, bury her at sea, take no chances. And by the way, I've told that story, and it's interesting that women find that funnier than men. But that being said, take no chances. What they've just described here, there are lots of resources to walk you through it. And again, here in Vermont, you've been doing this for some time. This is not something that's going to be a sea change for you, unlike colleagues south of the border in Massachusetts.
Okay, so first question. Can a listing agent still write an offer for a buyer as a customer if buyer brokers are required?
So buyer brokers are not required. Let's just clear the deck on that. So state law prevails in this settlement. So there's a section in the several hundred-page settlement that says unless inconsistent with state law. So let's talk about Vermont state law. You can be a seller's agent, you can be a buyer's agent, or you can be a broker's agent. And everything I'm going to say today needs to be prefaced with the understanding that you need to be having every one of these conversations with your principal brokers. They are the ones who, at the end of the day, own the client relationship and determine the type of agency you can practice, your fee structures. Those are all things that you need to be discussing with your principal broker, not individually. So get with them and get on the same page. But the bottom line is, yes, you can still have a customer. What triggers the settlement and the practice changes in the settlement is if you're expecting a fee from the buyer, right? You're expecting the buyer to pay your fee, that's what triggers that information. If you're going to switch sides, your code of ethics and the settlement agreement require that you disclose that switching aside. So if you go out with them and they're a customer and you're going to swap sides of the fence, you're going to have that buyer representation agreement. Here's an FYI. The VA just came out with that new guidance that they're going to temporarily suspend the prohibition of buyers being able to directly compensate their agents. Well, read that 2-page document you just got this morning, because guess what? Your buyer agency agreement now is considered part of the loan package. So you're going to have to provide a copy of that buyer agency agreement to the lender and the appraiser. That's right in that page 2 of that agreement. And that agreement also encourages the buyer to negotiate with you on your fees. So the short answer to the question is you can absolutely cross the threshold as a broker's agent. If you're a designated agency firm, you can practice broker agency within your firm, right? You can be the seller can have their designated agent, and you could be a broker's agent with a customer if your firm allows you to do that. But here's what you're going to have to do going forward. There's no more MLS for you to go and look at the splits. There's no more compensation out there. You are allowed as a brokerage to continue to publish offerings of compensation on your own website, but you can't put it in Showing Time. You can't put it in any national aggregator. So you're gonna have to work harder as an agent to call up, and I'm gonna have to call up Carolyn and say, Carolyn, on your listing on Main Street, are you offering compensation for brokers agents or buyers agents, and what is it? And then you as brokerage firms are going to have to decide at what level are you comfortable with that to memorialize that. We have a cooperation agreement in our forms library. That is one way to memorialize the compensation offering. If you have a comfort level and your broker's okay with it, you could do it through an email. If you have a good relationship with that agent, you know they're trustworthy, you could say, yeah, I take that at value. So yeah, that's a long-winded answer to say, yes, you can have customers.
And I would just add to that, not that this is a change as a result of the settlement, but make sure that customer knows in what capacity you're working. That is critical to make sure, transparency is going to be the key, overarching this whole conversation that we're having. So make sure the consumer knows who you are and how you're operating in the transaction, because you don't want to be halfway through and have them be like, well, I thought you were representing me. And then that's a very messy situation that could derail the whole transaction.
That's a good point. We are talking at the state level, so we all know, right? Before you show a home, that's one of the biggest triggers for the mandatory consumer information disclosure, right? We're talking at the state level of perhaps developing either a video or some sort of consumer-facing education that goes beyond the consumer disclosure to talk to consumers about their choices when working with a real estate professional, so that you're not having these rushed conversations. And we were talking during the break, like your buyer counseling sessions are going to have to happen earlier and be more informative to have that transparency level elevated.
Any questions on, yeah?
In the settlement, it said, written agreements are necessary for touring a house. Does the consumer disclosure count as an agreement? No.
Consumer disclosure is just that, it's a disclosure.
So you couldn't show it as a customer. You'd have to have them sign an individual.
No, again, you can. So the test for a written buyer agreement being required is if you have the expectation of getting paid by that buyer. If you plan to cross that threshold as a broker's agent, not getting paid by that buyer, again, I agree, you better disclose that and talk to them about their choices, but you wouldn't have a buyer agreement at that place. And remember that our administrative rules have very clear requirements about what's required. You have two types of representation, right? You can be a seller's agent or a buyer's agent or a broker's agent, but on any of those three cases, it's very specific in the administrative rules of all the elements that are required in there. When it starts, when it stops, how you're getting paid, what your services are, any limitations on those services, it's all spelled out. That's why we're way ahead of the settlement. We've always required that. Some new things are going to come in there. We're going to have to shout from the mountaintops that commissions are not set and they're negotiable, right? That's going to be, they're going to want to see that over and over again. We do not set commissions. Commissions are negotiable. That was kind of put to the wayside before.
Okay, so talking about that, commissions, how to talk to buyers and sellers about them, and I'm guessing that's going to follow the same categories of what they are classified as.
Yeah, I mean, I think that's really where your value statement is going to come into play a lot. You know, again, you're in a better spot here in Vermont than a lot of your colleagues across the country that haven't been using these representation agreements for buyers and sellers. But think about it as like a listing presentation that you're going to be having a conversation with your buyers, hopefully before you're actually at that point of touring a property that triggers this, so you can take the time to go through the agreement and make sure they understand what capacity you're working in, how you expect to get paid, how much you're going to get paid, and their options for satisfying that obligation to you. Are they going to pay it out of their pocket? Are they going to seek it from the seller? Are they going to seek it from the seller's broker? What happens in this scenario if there is no offer of compensation? Those are all conversations that you want to be having, and that you want to give yourself time to have that conversation. And that's part of the the inception of your relationship, to really build that foundation of trust and understanding that you're working as a team together and that your services aren't free. And this is, these are the possibilities open to them in how to satisfy that financial obligation to you. But it's really going to be a more robust conversation, particularly when it comes to filling in those blanks of how much you're getting paid. My recommendation has always been leave that section of your contract blank when you sit down and have that conversation. And then when you're having that conversation, you can say, my fee is blank. And then that opens the door to have that conversation. By saying that your fee is negotiable, it doesn't mean you have to undersell your value. It doesn't mean you have to accept whatever a buyer is willing to pay. But that's your opportunity to say, this is the service I provide, this is the fee I expect. The consumer then has the opportunity to say, well, I was really only hoping to pay Y, and you can say yes, no, or maybe meet in the middle, and it gives you that opportunity to satisfy that negotiable requirement that they want to see as part of this settlement. And then you can fill it in and sign it, but I really want you to be careful with the e-signature platforms, because it's so easy to just shoot a contract off for signature, and you click, 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 and they're not reading it. They're not having that understanding, which could lead to trouble.
Right, electronic signing, but have the Zoom call with them where you're going through the content.
But I think when it comes to just generally speaking about disclosure, and disclosure in any capacity, whether it is disclosure as to your services, lender services, title and settlement services, whoever it is, that you really can't over disclose. To have conversations early on so people understand what is going on. And how this all works. Disclosure, say no one has ever really had successful litigation against them for being, for over disclosing. So everything you can do at the earliest opportunity to explain to people, if you've got someone that you're talking to and it's like, oh, you'd like to buy a house a year from now. By the way, here are some things to think about before we even get to that point, because this is how things work. So you understand that. And educating the consumer, there's an old saying in marketing that a person is smart, but people are stupid. And so, an individual, you sit down with them and you explain it, you're probably going to be able to, reach that sort of understanding. But, again, if you're working with someone and you're sort of grooming a buyer, perhaps they're cleaning up their credit, whatever the issues may be that you're assisting with, again, a value proposition, talk about it early on. Again, in our industry, and I say in the entire real estate industry, our value proposition, it's been a lousy job. Years ago, a guy who ran, he's now a leading expert and consultant for the lending industry, but he ran the closing operations for the old GMAC mortgage group out of Philadelphia. And they did, and this is 15 years ago, they did recordings of people who had bought homes over a period of the previous 6 months. And these were first-time home buyers, experienced home buyers. Some had bought and sold 6, 7 properties. They were ethnically different. They were, some were men, some were women, some were single individuals, some were married. So it was a wide range. And the video he always showed, he said, this is my favorite guy. He said, interviewing someone and it's on film, said, well, sir, do you find the home buying process and closing process to be complicated. He said, no, I think it's extremely simple. I said, really? And you've sold like 7 houses? Oh yeah. He said, you know, when I get to closing, I know they're going to screw me, I just don't know how. And he said, this guy just was reconciled to this. You don't want to be part of that at any point in time. You want everyone to understand as to what the value proposition is for every aspect of our industry.
One other thing to keep in mind, we're really focused on the buyer piece here. I get it, because the settlement's really focused on the buyer piece. We have to start the conversations with our sellers, right? Because I'm already seeing in the MLS, because compensation's still in there, a lot of zero offerings. Part of that is because people are reading and seeing stuff on the news. But we have a job to educate our sellers about the benefits of offering compensation, about the underserved buyers that are out there who can barely scrape up a 3%, 5%, 10% down payment, who don't have the ability to reach into their pockets. You have to share with your sellers what happens when they don't offer compensation and the potential risks of that. You can't make declarative statements like, people won't show your home, because that's not true. And buyer's agents can't filter listings based on zero offerings. That's another prohibition in the settlement. But what you have to do is educate your sellers of the value that a buyer's agent brings to the transaction, about the decreased liability that brings to it, and that the opportunities it opens up for a whole other pool of buyers who otherwise couldn't afford to buy that home. So it starts with the listing brokerage or the listing agent really doing a good job educating the seller. And then that opens up what we were just discussing about the different ways a buyer's agent can get paid, right? It could be directly from the buyer, it could be a seller concession, it could be an offering from the brokerage firm's own agreed upon fee that they have with their seller. All those things are still possibilities as they are today.
I think that's an excellent point, and I would just add to that as well that your conversation about commission doesn't start and end when you sign that contract with your client, whether they're a buyer or a seller. That commission amount remains negotiable, right? So even if your seller says, I don't want to make an offer of compensation, you want to make sure that you're making it clear to them that that doesn't mean that a buyer might not still include that with their offer and still ask for it, that it can be negotiated as a term of the contract. So make sure that they know that offering zero doesn't necessarily mean that all buyers are going to accept that zero at face value. There might still be ongoing negotiation with regard to what that number looks like.
Yeah, we talked about that earlier at a break. The seller doesn't say no, right, until the seller has an offer in front of them and rejects it. So when I was at the mid-year meetings for NAR in DC in May, there was all these discussions like the seller won't, the seller won't, the seller won't. And my reply was, the seller doesn't say no until the seller's got a piece of paper in front of them with a ready, willing, and able buyer with terms. And they either accept those terms or they don't. Some of us are old enough to remember, Rich and I joked about this last night, price reductions, extending a 1-year listing agreement. I can guarantee you a seller who wasn't willing when they signed that contract a year later, who has a breathing body in front of them, is going to think about that commission a lot differently 12 months later.
Quick comment about that. So, all of us in this room have sat across from a buyer at their office, but I get a call on a Friday at 2, the offer deadline's Monday. Buyers are like, I don't have any time to meet. We got to get 20 minutes to see it on Saturday afternoon. How are we going to sit down and have a conversation with them? They want to get to the house and get their offer before. Let's say in practice, in theory, it sounds great. In practice, sitting down with every buyer that you want to bring to the buyer's going to have to understand that. You can't go see the house Sunday. I'm sorry. You have to meet first for an hour, go over everything. Then hopefully there's a showing for you before the deadline and you get the house or you don't. That's just a comment about that. Just seems that in theory, it sounds great. In practice, I don't see a lot of that. And then buyer
Have a conversation with them in the car. When they call you and say that, say, yeah, I understand this is a short turnaround. Let's talk, right? That you can say before I can show you this property, I'm legally required to have you sign these documents. One explains what my relationship with you is in this transaction. The other is a contract, and your contract isn't a marriage license. You can make it for that property. You can make it for that weekend. You can make it shorter term, that you don't have to enter into this huge, scary, long agreement, but you're fulfilling your obligations under the settlement, and you're also protecting your interests and the client's interests by doing that. It doesn't have to be, sitting across from each other at a table for an hour explaining it.
And then the buyer calls another agent next week and wants to see a property, and they just sign this paper, and they sign the paper. Now they have 2 agreements, and the buyer has no repercussion or education. The fact that they need to honor the first agreement they signed if they didn't. I'm just saying, in theory, they didn't put a lot of thought into this thing. So my question really is based on seller information. We can put that on our personal website.
Yes.
Correct. Correct. So can I run a Facebook ad directed to agents in Chittenden County that says we're paying 6% commission on this, link you go to my website?
No, that's a third-party site.
No, the carve-out in the settlement is specific to websites. I personally, and I don't know if Chuck and if you both agree with that, I think that sort of advertising, A, I'm not sure your brokerage would allow it, and B, I think that would violate the intent of the settlement.
I can still put a link to my website landing page and an ad that says house for sale.
Yep.
Yeah. And again, that's what things are as we are sitting here today. Department of Justice doesn't want them anywhere.
Right.
So, a year from now, maybe what you're describing isn't going to work. But right now, this appears certainly to be the case. And I'll say too, the regulators, to your point, it's like, well, okay, they call you on Friday, you got to get like 24 hours to move forward on things. The regulators want this process slowed down. That's part of the, they want people to be able to deliberate. This has been going on for years. And just recently, CoreLogic put out information that that the majority of home buyers, when they decide on choosing a lender, they go to one lender. They don't shop. They don't look at a second lender. They just go wherever they think they're going to go, whether it's to here to the credit union or if they're going to go to Rocket. I mean, whoever it is they're going to go to, that's where they go, and they're done. But for years, regulators were like, no, we want consumers to spend the time, deliberate, shop around. There's no time to shop around. You got to move fast, and especially in a market where we've got a seller's market. Yeah, if you don't have an offer in 24 hours and perhaps even over asking price, you're done. You're not going to get the place. So yes, there are impracticalities that are designed to be there. By the regulators. They want the process slowed down.
So you're saying they want the process slowed down. We are in a world of text, everything fast, immediate. Do you foresee that they're going to try and implement some requirements of once an offer comes in, nothing can be signed for 48 hours? Like, there's no way to make it slow down unless you put some sort of rule in place.
No, I don't think that would happen when you get into an offer, when you're actually into negotiation about buying. But I think all of the choices the consumers make as to their real estate, their realty representation, as to their lender, as to who does the closing, who their legal counsel is, all those things. Yeah, and then once when you're in the fray, it's like, everything has to happen in 24 hours. Okay, well, we'll do the best we can. So no, I don't think that's going to be something that is going to be slowed or is intended to be slowed, because realty is a pure marketplace. We're like some sort of Arab bazaar. It's like, here's what the price is, buy it now or get out of my way. It's always been that way. It's, the phones ring one day and they stop ringing the next. So it's a pure marketplace. And so no, I don't think that's ever the intention to do that. Could it happen years from now? It could, but I don't think that's going to happen.
Just a question.
Regarding fire agency compensation, my understanding it has to be as specific as specific.
Yes.
So there's no variances of range or.
No, as long as it can be, it's clearly ascertainable and calculable. It just can't be something like, my brokerage firm will accept whatever the seller's agent or sellers are willing to offer. Like, that's open-ended, right? That you can't calculate that. That's not definable. But you could, any formula you want is permissible. Like, if you buy a house from 0 to 500,000, my fee is blah. If you buy a house from 500 to 6, it's blah. If the seller's agent is offering something, I'm willing to accept that and not hold you for the difference. I mean, as long as it's got to be clear and it's got to be it's got to be transparent, and it's got to be known.
That answers the, the thought of the tiered,
Yep.
price points or no less than.
Yeah, and like, we can date, we don't have to marry. It can be for one property, a location. Again, if your brokerage firm allows this. It can be for up to a year, right? That's what's allowed under statute. You can do it for up to a year. It can be for a day. It could be for an hour. It could be for an afternoon. And to Trevor's point, worrying about, you just have to make sure they understand what their obligations are, where they are, and where they start. Are there going to be procuring cause and arbitration issues? Yes, I promise you, that's going to happen. We're talking about that at the national level. They don't have any, I'm on pro standards at NAR, they do not have any answers on this. But I can tell you that I'm going to practice making sure I memorialize whatever the offering is. I'm going to make sure it's clearly understood and documented. I'm going to make sure my consumer knows that if I start the chain of events and they decide to go somewhere else, that I could be entitled to compensation. We got to have those conversations.
Yeah. Well, it's definitely going to be an industry change, but I feel like this is like a marketing opportunity to have a buyer on a long-term basis, because you can use the settlement as, this is why we're going to have this discussion, and then maybe they will marry you for the process rather than dating for one offer. So to me, we've all had to go through industry changes where we've had to change how we do things. I mean, I can't tell you how many things we've changed since we started doing title searches. So if there's an opening to make a relationship with a person, that's what you guys excel at. So to me, that's the marketing opportunity there. Elise?
Just to piggyback on Jason's question, so to be clear, in the buyer agreement, it could say, A, if you're my client, this is my percent. B, if there's no broker offering, I expect this amount from you as my buyer. It can be an A or a B.
It can be any and all the above. I think VAR is going to end up possibly tweaking the buyer rep agreements to try to make it a little bit, give options, but here's what we don't want to do. We want to tell you how to practice, but as a principal broker, you're going to have to decide what your ranges are and what your fees are, and agree to those with your folks, and then have a transparent sit down with your buyer and talk about all the different ways it can happen, from seller concession to broker offerings to them reaching into their pocket.
Yeah, and keep in mind that it can come from those multiple sources as long as it doesn't exceed that amount that's listed in your contract. So, you can say, all right, my fee is X, but they're only offering Y, so that leaves a difference of Z. How's that difference going to be made up? Are you going to include it as a term of the contract? Does your buyer have the ability to pay that out of their liquid resources without, impacting their financing? That's where you have those conversations about the different methodologies.
And does anyone remember seller agent, buyer agent bonuses? Remember those?
Yeah.
So there's all sorts of talk about what has to happen with those. So there's no rules about what has to happen. Here's what has to happen. You got to have a discussion with your client, your buyer client, that there is an offering, and then you have to talk prior to putting in that offer about what you're going to do with that bonus, right? You don't get to just put that $2,000 in your pocket and walk home. You don't get to get it in the parking lot. What you have to do is have, Rich, you're my client. You need to know that before we put this offer in, the brokerage firm's offering me an extra $2,000 if I bring a contract. How are we going to handle that? And this is what it means in terms of our agreement about how I'm getting paid and what I'm charging you. So we can either reject it, I can take it off of what you owe me, we can rebate it to me. There's all these different ways, right? But that's that transparent discussion that has to happen. What used to happen in the olden days? Well, we never told them. I'm saying we, I'm putting us all in the same bucket. We never told them. Our brokerage firm got the check, and it's like, that's what they want to stop.
Yeah. Yeah, and home builder bonuses.
Yep.
Very common in various, yes, you got to disclose that.
Yeah, exactly.
Yeah.
Just for fun, while we're talking about this, let's assume that we've got.
It is fun, isn't it?
This is so much fun, and I appreciate you all. So let's assume that we've got a buyer agency agreement signed that's got Y in it, and then you've got a listing agreement that's signed that is X, and X covers the listing agent or listing agency, and it happens to be more than enough compensation and is actually in excess of what Y is. Where does that extra go?
So that's that discussion I just said, right?
just similar, but not, he didn't exactly touch on it. It's similar.
Right. Well, so there's two discussions, right? One is with the seller. So one of the discussions is with the seller about whether the fee you charge is all yours or whether it's shared, right? Because some of us are still going to charge the same we used to and just still share the fee, right? We might do that. That's an option. Or is my fee as a listing brokerage X, and then Mr. Seller, let's talk about whether and how, because we're required to under our administrative rules, right? If and how we're going to compensate agents representing the buyer, if and how we're going to compensate agents that are broker agents, right? Those are required in our administrative rules. So Mr. Seller, let's talk about if and how we're going to do that and how much it's going to be. And then so that's the conversation with the seller. The conversation with the buyer is, hey, guess what? They're offering more than I'm charging you. How do you want to handle that when we put your offer forward? It may be that you have a buyer that is in love with you because you've shown them 50 houses and they're like, let's amend your agreement. I'm okay with you accepting their offering and getting paid more. Because if they're paying it and willing to do it, great. It may be that they get a seller concession. It may be that you modify the offering and say, we're going to reject what you offered and we only are going to ask in the contract for the lesser amount because that's my obligation. So it has to be the transparency. That's the key. It has to be discussed and agreed upon with your client. Your client is who you have the relationship with, right?
In that case, though, the seller agreement also needs to be modified.
Well, that's between the seller's broker and the seller, right? That's and to talk about what their obligation is at the closing table. Yep, that's between let the seller's agent worry about that. If you bring the offer and they're sitting down reviewing that offer with their seller, then the conversation is, hey, they're asking for less than we offered. Maybe you said, I'm keeping it as a brokerage firm. You say, maybe your agreement states in it clearly, my fee is my fee. Or maybe you say, hey, this is a windfall for you. I can reduce my commission by X.
So, Dave, you got to look at the right side of the road. You guys got to make more noise over here. Smarty.
Question for Charles, because you're over 50 miles away and you're looking at the broader view than we are. And when you talk about dual agency, so common in other areas, and you had a reference of your friend there that was representing both sides, you seem to have a straight face when you were saying that. And so, in a situation, the question is, I mean, if I'm a dual agent in another state, I have two clients that pretty much to begin with. So if one client says, a buyer client in the situation that they want to offer $20,000 less than full price, but they'll pay full price if they have to. So as a dual agent, how am I representing that seller at that point? Am I not telling the seller that? In which case, in my mind, I'm not representing the seller well, and if I do, I'm not representing the buyer well. What's up with that?
Well, and thanks to everyone for coming. We really enjoyed this morning. No, but your point is well raised, and and especially, in those states where it's clear because the term is used, a fiduciary relationship. Who do you represent? And under old, agency law, it's like you can't serve two masters as to how this works. My friend who does this routinely. And he does it again permissible. It's under Ohio law. He could do it all himself, but what he does is he gets an agent friend, perhaps a starting agent, someone who's just getting underway, don't have much business. He will pay them out of his commission, and they will be the agent of record for the buyer. So if that buyer has questions and they want independent counsel from a real estate agent, they can do that. He has always felt that to be the safe way to do it. And
I wouldn't really consider him to be a dual agent because he's stepping out.
Well, he's picking up the whole commission, but then he's paying that agent under a sub-agency to do it. One of the arguments, though, actually by some of the consumer groups and regulators, we've obviously you've got a listing agent and broker, you got a buyer agent and broker. But some of their arguments have been, well, really, though, because that buyer, agent, or broker doesn't get paid unless the transaction closes, maybe they're not representing their client as zealously as they need to be. That is an argument that some consumer groups is that, well, you're actually being paid by the seller. So right now, who are you working for? Because if the seller, if it falls through. So they have argued the opposite side of that, well, really we have that circumstance now. I would say that's not really true, especially here, as to how you all do things. But yeah, that certainly is an issue. And for aspiring young attorneys, it may be something that will make their career when they eventually get to litigate that issue, as to who exactly do you represent, and how zealously did you represent them? Are we going to have something like, as we see in the legal profession, inadequacy of counsel as an argument for on appeal or to overturn a conviction? Well, will inadequacy of representation become a cause of action in those states where it's like, well, yeah, they said they represented me, but now a year later, I found out they knew the basement leaked, and they never said a word to me. And of course, I didn't get an inspection, and I didn't do all the things I should have done. But all that being said, could that be, moving forward, especially in those states where dual agency is permitted, could that be a cause of action? I am sure that somewhere there's a first-year attorney thinking that's how I'll get my first Lexus.
So there's conversations happening still in the state of Vermont about transactional brokerage. Don't hold your breath, because most of us think that that's just a thinly veiled way to get too close to dual agency. And at NAR, we have this thing called the Hub. It's a big listserv that's obnoxious, but my good friend, who's a real estate commissioner in Rhode Island, started a thread which caught fire and is still kind of going a little bit, which basically said, wouldn't it be great as if part of this settlement, if we took our Realtor Code of Ethics to heart and totally did away with dual agency across the United States, realizing that there's no way in hell, and I fully support this, that you can serve two clients. You just can't do it. And in the states that think they can, I don't think they get agency. That's my opinion.
So with the settlement, as far as concerned, the DOJ sees the sellers as a protected class.
Yeah.
The DOJ sees everybody as a protected class. Their feeling is that we're all out to screw everybody. And I can tell you, in my industry, in particular, the Consumer Financial Protection Bureau, they really think we're out to screw everybody, and that the lender is too. So yeah, we'll see how DOJ moves forward on this and what avenues they go down in regard to enforcement. My guess is they will probably be more interested in the buyer side than on the listing side. Because again, on the listing side, it's a little different animal, but the buyers they just don't really understand how this works. But yeah, I think we'll see. I think we'll see justice. But I think that's the side they'll probably try to fall down on.
This lawyer should represent all the non-homeowners above the age of 18, the potential buyers in the country, and take a class action lawsuit against.
Don't get Sarah to resign and do that.
Yeah. Well, yeah. Well, and we've seen. In a different law under Equal Credit Opportunity Act, litigation that went on in Chicago against a mortgage lender, where as far as their advertising, and the argument was that it was trying to convince prospective borrowers to not borrow through them, because on a radio show, the owner of the company made some disparaging remarks about the south side of Chicago, which was pretty easy to do. And when they finally did polling, people who live in the south side of Chicago said, he's right. But that being said, the courts there severely limited that, as far as prospective doesn't mean anybody who's ever worn shoes or has ever, or owns a radio. It's someone who's actually an application. And I think that's the same thing too. A prospective home buyer, I think it's going to be somebody who is actively looking to buy a house, and there's some activity that is demonstrable before you can make that argument that they were a prospective home buyer, and then therefore they were somehow impacted imprudently in the industry. It's not just anybody who might eventually buy a house.
I think we've all had a lot of discussion about the buyer side transaction, and I think we're all getting that. But I think the discussions about the seller side are going to need a lot more talking, because I'm sitting here saying, what am I going to tell my seller I mean, I want a bag of nuts for selling your house. But somewhere along here, there's going to be a buyer representative, and he might be working for the buyer, and he might be working for me, and he's going to want to get paid. Now, if he's working for me, I can readily say, well, I'm going to pay him, we ought to pay him, or you could pay him a box of crackers. But if it's a buyer representation, they figured out what they were going to pay that broker. He's going to get a peck of apples. And how am I going to put my box of crackers and pay a bag of apples? It's a discussion that's going to be difficult because of the two different ways. One time it's coming from, if it's a buyer broker, it's being paid, probably basically the settlement saying it's being paid by the seller or the buyer. And the buyer's going to say, I want the seller to sit and pay it. But if it's an agent that's working for me as a broker's agent, then it's coming, typically would come from me as the broker.
Which is still an option. If you have a chance to, if you see a CE class taught by Kim Allard and anybody from Dynamic Directions, Kim's out of Massachusetts. We've had her, VAR's had her here twice.
Kim is excellent.
She's amazing. She will talk to you about the language you use to talk about neutralizing the buyer's obligation. There are ways to have this conversation with your seller, educating them about how it opens up opportunities for more buyers and more activity on their home. And at the end of the day, remember, sharing your commission is still an option. So you can still be dealing with your crackers and apples however you see fit.
And I think one takeaway, from all of this is to remember that the discussion about compensation is going to be ongoing. It's going to be happening much more frequently throughout the transaction than it probably historically has as a result of this. So you should be prepared for all those different scenarios, and when it comes up as a term of an offer, for example, and being able to explain that to whatever side of the transaction you're working with. Of how do I turn my crackers into apples? What are the options that we have here? So I think it's going to be a much more prominent discussion point throughout the transaction going forward than we've seen before.
Yeah, and I'll just add too, you are dealing with a rising tide from national press that, oh, well, now, we're not going to have to pay, buyers, agent commissions, and sellers aren't going to have to pay them, because that's sort of the synopsis of the headlines that come out of the national press, and it's like, first of all, that's not true, and second of all, yeah, you now have to counter that and say, well, yeah, you read that again in the Wall Street Journal, but that's not really how things work. And this is in fact, here's what I think you should do as a professional. I'm trying to guide you. This is how fees are paid. This is how the dollars work. And if we can reach agreement, great. And if we can't reach agreement, well, via con Dios.
Or not. Non-realtors, what do they have to do? I mean, they have to follow OPR's rules and the MLS rules.
So remember that the settlement applied to protected, over 1 million realtors, anybody that was under that sales volume threshold. So we're all protected, but the practice changes manifest themselves through the MLS Policy Committee. So the MLS Policy Committee released the new MLS model policy rules first week of May. So Prime MLS is in the process of implementing those. So just like non-realtor members today practicing under Prime MLS are subject to the exact same rules by agreeing to be members of Prime, they too have to follow those. They're not protected under the settlement unless they go and do the appendix and opt in, but they will have to follow the rules. So essentially, all of these practice changes are going to come through and it'll be Prime MLS who has the audit responsibility for your buyer agreement. So if someone were to accuse you of not having a buyer agreement when you toured a home and you were acting as the client's rep, that Prime could say, I need to see, just like they could do with your listing agreement, need to see a copy of your buyer broker agreement. And that's what the talk is going around nationally. So, luckily in the state of Vermont, the number of non-realtor members is really low. But as you saw from Chuck's slide, like if I were to take you to California, they got over 500,000 licensees, and a large majority of them are non-realtor members. So we're going to be okay, I think.
Yeah, and organizations that are like the Realtists, they're joining in on this. I mean, they may not be NAR members, they may not be under the settlement or even the litigation or in the antitrust view, but they're not going to want to be outliers, and because it just creates that much more confusion for them and for their clients and for their trade professionals. So, yeah, we're already seeing that those organizations that are outside of this, they're like, yeah, we're going to play ball with this concept too.
So one of the questions that was asked is, how are you going to handle closing cost concessions for compensation?
So remember that nothing's changed in terms of, matter of fact, it's gotten better. So Chuck hit on it. I'll use a term different than him. IPC, interested party contributions, right? That's the max amount that sellers can contribute without going over that limit that then violates the FHA, VHFA, all those limits. They have issued a declaratory statement that's saying that broker compensation isn't going to bump up against those interested party contributions. So what does that mean? That means that in addition to, if we get back to a balanced market where your buyers are asking for closing cost concessions for things like mortgage points, home repairs, things like that, that they can do that, as well as we can start to see broker compensation, buyer broker compensation, right, being part of an offer to purchase with a seller. The seller can make those contributions without bumping up against those. The big win, this is your NAR dues dollars and advocacy at its best. The big win was on the 11th, 2 days ago, the Department of Veteran Affairs saying that buyers can now directly compensate their brokers for brokerage service fees. That was prohibited up until the 11th. That was NAR's advocacy that got you that win, got us that win. Read the 2-page document that just came out, because your buyer broker agreements are now part of the loan package, and they will go to the lender and the appraiser. And there's some other conditions in there about how those will work. They'll have to be on the specific closing disclosures, the fees. You can't pay them outside and in the parking lot, like Chuck was saying, warning us not to do. So that's the short answer to
that. Cooperation versus collusion. How do you draw the line?
So cooperation just means you're working together. Colluding means you're working together to, fix prices, for example, where there's that, sort of criminal element to it. But, even our NAR Code of Ethics calls for it. You must cooperate with the other realtors in the transaction. That's Article 3. Doesn't mean you have to compensate them, right? They're always separate. But collusion has more of that negative intent to it, that you're looking to serve your end with a group of your competitors, so to speak, right? That if you guys are having a conversation, say, all right, well, what are we going to charge buyers in Essex when they purchase a property? That's more the collusion aspect and not the cooperation. Cooperation is saying, I've got a buyer who wants to purchase your property. Are you offering compensation? What is that compensation? And then you're having that sort of cooperative arrangement.
And that was part of the argument to Keith's point that, like in the Sitzer Burnet argument there, the antitrust violation was collusion. That NAR, by virtue of its rules and because of a lack of transparency to consumers, that they were colluding to set prices in regard to things, which is an antitrust violation. And that's collusion. But yeah, cooperation, very different. Cooperation is you're being cooperative, as versus, well, why don't we go meet outside and talk about this and see what kind of scheme we can put together.
But remember also, you're only required to cooperate when it's in your client's best interest, right? There may be situations where cooperation is not in your client's best interest, and that is perfectly acceptable under both the Code of Ethics as well as your fiduciary duties that you owe to your client.
So we'll get to it in a second, but one of the things that the cooperation conversation opens up, there's so much focus on what's going on with buyers, right? Which is where a lot of this should be. But as listing brokers or agents, we have to start having the conversation with our sellers at the time we take the listing about what it means to cooperate, right? What it means to potentially compensate, and why it's in the seller's best interest to do both of those things, and what it does to the marketplace. We need to remind them about buyers who barely can save up for a down payment at 3%, 5%. They're saving everything they got. Remind them that you're going to miss out on a pool of buyers that can't afford to directly compensate their agent. So we need to have those conversations with sellers so that I'm already seeing it in the marketplace, 0 offerings. How is that in the seller's best interest? They're potentially limiting the pool of buyers that's going to come to their home. Educate your sellers. Tell them, and tell them it's negotiable, but tell them all the different ways the deal can go down. Tell them they might, if they decide to see 0, that they might see an offer come in that has compensation in it. Warn them so that by the time you're reviewing that purchase and sale with them, and that comes across, it's not a surprise. You've already had the conversation. Hey, we might be asked for a seller concession. It's just another method, another way to talk.
And to piggyback off of what Chuck had said earlier in his presentation, I think we're seeing this initial knee-jerk reaction from sellers that are hearing all of this information in the media that's bombarding them and saying, you don't have to pay buyer agency compensation anymore. And so sellers are going to come and push back against you and say, well, why would I pay it if I don't have to pay it? And that's where you can come in and you show your value and you say, you're right, you don't have to pay it. But here are the reasons why it may be in your better interest to pay it. And as we start practicing under the new framework, you're going to start having anecdotal stories that you can share with your clients that says, all right, well, I listed 2 houses in Essex. One had an offer of compensation and another didn't. They were fairly comparable properties. The one with an offer of compensation sold 3 times faster than the other one. So you're going to be able to start having those experiences that you can share to highlight that benefit in your local marketplace, to help a seller better understand that, you have more prospective buyers, you're going to get a more favorable offer. It's just, basic economics.
Well, and revisiting, right? Revisiting and revisiting, because, right, sometimes you don't know when you list the property whether you're going to have 27 offers. No, I mean, you have your good ideas, but, you never know these days, especially it seems like we have both ends of the spectrum. I'm seeing buyer concessions again, but I also have heard of, houses getting 20 offers. So you may start with no compensation, but you're going to have to keep checking in to see if that's where you're going to stay. It's a little more communication on the agents, whether you're on the seller side or the buyer side. There's a lot more discussion about money, and nobody likes to talk about money, right? Like, we don't want to talk about it. It's bad. It feels bad, right? But we have to talk about it. That's kind of where we're at.
What's the most effective way to let everyone know what your compensation offer is?
Well, I think that's where you can let your creativity shine, because there's one very specific way that you can't do it, but outside of that, the world is your oyster. So you can't put it in the MLS, you can't put it in showing time, for example, but you can have it on your brokerage website. If you host an open house, you can have a placard on the counter that says seller is offering X amount in compensation. You can answer direct inquiries from prospective cooperating agents. You can have a banner behind an airplane that flies over the baseball game. You really have a lot of different options as far as how you share that information. The caveat I would put on that is I would be very hesitant to put anything with commission amounts on any type of social media or forum that allows commenting, because that's just asking for trouble. But yeah, you have a ton of options. You could send out mailers. You could do door hangers. Lots of different ways that you can share that information, as long as it's not on the MLS.
Just to clarify what you said was, so if our website takes our MLS feed and then we do a manual entry that's only shown on our website with a compensation amount, you're saying that will be legal?
As long as it's only on your listings.
Can't be part of the IDX feed. It's not going to be a field in the MLS anymore.
Right.
David, I'm hoping you can help
help me with this a little bit. As a non-designated agency, after the third week in August, and like for yourself, if you're primarily doing listings right now, and you get a call from a customer who wants to go in and see your listing, we now, with the need of having to have the buyer broker group before we go in, we're unable to facilitate that.
So you'll still be able to do that. Showing your own listing is a client-level service to your seller. So as a non-designated agency firm, any of your agents can do that without a written buyer agreement. So what triggers the need for a written buyer agreement? So the test is, number one, touring a home. Touring a home either virtually or in person. And the second test for that is where you're expecting to be paid by the buyer. So if you plan to tour a home with a buyer who expects to pay you, you have to have that written agreement, and it has to meet all the terms of the Vermont law, right? So that's where Vermont law and our administrative rules comes in, where you have to meet all of those terms as well as the terms of the settlement. The amount has to be clear and conspicuous, has to be calculatable. It can't be whatever the seller's offering, whatever the seller's agent's offering. It has to be very clear and spelled out. Can you still work with customers? We got that question a ton on the last one. Yes, broker agency, there's 3 types of agency in the state of Vermont. Seller agency, buyer agency, and broker agency. If the other side is offering to cooperate with brokers agents, you can show it. I can tell you what I'm going to be doing and what you're all going to be doing after the 17th. You're going to be calling the listing brokerage and the listing agent and saying, are you offering to cooperate with brokers agents? Yes or no. Are you offering to cooperate with buyers agents? Yes or no. Are you offering compensation to brokers agents? Are you offering compensation to buyers agents? Any of those conversations, back to what Kate was saying, is they need to be transparent and had with your buyers. The buyer needs to know where the money's coming from and who's paying it. And you can't accept more compensation than you get to dictate in your agreement with your buyer. So if you have a specific amount with your buyer and there's a bonus or an additional amount coming from the listing side, you don't get to keep that. What you have to do is have a conversation with your buyer about, hey, the offering's more than what I'm agreed to charge you. How do you want to move forward with an offer? Do you want to reject that and accept less? Do you want to credit? How do you want to structure that? They want that transparent conversation with the buyer to happen early.
Thank you, David.
Yeah, just to follow up with that, David. I mean, so we've been talking a lot about this phone call frenzy is what I'm envisioning. So, I mean, don't you, tell me if I'm wrong to like jump the gun like 3 years from now, but don't you think like that's going to get old really quick with people like, I'm not going to call them back, or I'm going to, I've got somebody else that, I just feel like writing an offer with a seller concession is just going to be kind of more commonplace. Like, so in other words, if you've got a buyer agreement and you're going to take 2.5% or whatever is in your agreement, you could still see it on the first day, and if the listing agent doesn't call you back, you could still write a great offer and say, hey, I want compensation. So my assumption is that's just going to become the new way of getting compensated, because it's still a net to seller. If you really look at net to seller.
So yes and yes. Here's what I think is going to happen. There's a lot of smart people in this room. People are going to figure out, like Curtis has, that, well, so I don't get 1,000 phone calls, I'm going to add it to my website, and agents will know, and that will be good enough, and that'll work. Other people are going to send emails, and that email is going to be good enough. There are going to be some brokerages you deal with where there's going to be a trust issue, and you are not going to take a call or an email, and you're going to require, for your own practice, or your broker's going to require, a written cooperation agreement with that fee memorialized. You each have to decide going forward, how are you going to do this? This will sugar itself out. Nobody wants to, it's not in the seller's best interest if they are offering, because remember, it's the seller that authorizes either the sharing of your fee or the offering of their own fee. Seller, it's not going to be a good practice, and it's going to put you in trouble with the Real Estate Commission if you are not returning calls and representing your seller's best interest. So people are going to figure out very quickly, because remember the days when we used to show 15 houses on a Saturday and they didn't want any of them, and we did it the next Saturday? No one wants to make 15 phone calls. Right. So we're going to figure it out. We're going to
and I'll just add to that too, and talking about like emails. And the sort of black humor in the legal profession is E in email stands for evidence. And so, if you send over an email to someone, I would preface in it or put something in there that after consulting with my buyer or my seller, whoever it is, and discussing with them the various opportunities and the various ways this could be happened, could you then please provide to me this information? Always build something in there, presuming that sometime a regulator or an attorney is going to read that.
Good coaching.
So you always want to have that sort of cushiony language that that explains really the situation. You're not puffing anything, but it's like, yeah, I've been talking to my buyer and so forth and so forth and so on, and based on that, what can you do to help me out as far as so I have clarity?
But I am correct in thinking, right, that like if you're really trying to market things, both specifically to your sellers going forward as a net to seller, okay? So whether the seller offers 2% at a listing price of $500,000, or whether the buyer writes an offer of $500,000 and asks for a 2% concession, the net is still there, right? I mean, it's still the same.
Well, it's always going to come down, like, so I was saying in the last session, because when I was at the mid-year meetings, everyone was like, my seller won't, and this seller won't, and the seller said no to this. The only time the seller says no? When they got a purchase and sale offer in front of them, and you're reviewing the terms, and one of the terms is compensation, and the seller says, I will not accept that offer. That's when the seller says no. Because in a balanced market where, remember the days we used to get our listings that expired after a year, we used to have to get another listing agreement for the next year? Like, the seller that said no might change their mind when they've been 6 months on the market and they're not getting the activity and they got a breathing buyer. They might say, you know what, I'm willing to do that 4% concession for closing costs or whatever it is. So yeah, they care about their net.
If I can just get you to repeat, because when the plane went over, this whole half of the room didn't hear what you were saying about email. So if you can just re-say it towards this group.
Sure, I apologize. Yeah, well, I'd say, and the E in email stands for evidence. Whenever you're going to send over an email, again, think about what if a regulator, what if an attorney, class action attorney were to read this. And so as we were discussing, if you're reaching out via email or by text, anything that's discoverable, which at this point is everything, that you build in the language of that after consulting with my buyer client, my buyer customer, and discussing with them the various ways that the brokerage fee could be handled, could you please advise me what your sellers may be prepared to do or what the listing price to do? So you want to couch those things when you write those emails. Again, presume that sometime some attorney or some regulator may end up reading those. And email is a very cold-blooded thing. It is simply the words on the page. I used to have to deal with, I had 2 managers who would get into email fights. They would send emails to each other. They were both very, shall I say, untactful as to how they wrote. And then we put them in a room together. It's like, oh, actually, I agree with you. It's like, that was fun. Stop sending emails to each other. So again, yeah, you just want to be sure your emails are something that if it were to be discoverable later on by somebody, that you could with a straight face say, well, yeah, I know it's after I've already talked to everybody. I've done all the things that I am required to do by virtue of my profession.
And really, these days, right, AI can have you have a sample of one. I know you're very taxed for time, and I know you're very taxed with texting, but I can't tell you how many times you want somebody out of a contract and a breach, and I've got all these texts with no legal notice of the title problem. No, we're going to terminate if you don't get back to me. This person didn't email me back in the window. This person texted me. Let me send you a screenshot of the text, which has no information in it. So I think you have to find a way to document your file and build your file with layers that look, and this is your operating procedure. Because 20 years from now, none of it, like I've been doing this now too long. If you say, I represented you 10 years ago, actually, if you said 10 months ago, I still probably wouldn't remember, right? But I know that this is how I do things. This is how I always do things, right? Like, this is the process I do. And what they're saying is this is requiring a new process. It's not just going to be a new process for sellers. It's going to be a new process for dealing with buyers, and you have to think through it, create a change in your normal operating procedure, and implement it. And a little bit of what we talked about in the last session is you can't wait for the forms committee to get there. right? So you have to, this is about transparency, this is about having things in writing, signed by the right people, so you have your evidence trail. It's really hard for regulators to go against a signed statement that everybody read and understood, whatever form it takes, right? So
in purchase and sale, special sections 11, it gives us the opportunity to fill in, correct? And as I know, the purchase and sales between the buyer and seller, but if buyer and seller signed the document and whatever is in special sections 11 becomes part of the document, correct? So with that said, for example, if you say, you know, the agency, such and such agency, XYZ agency accepts this much of the sale price at the time of closing from seller, will that constitute really what's needed in there to help with this conversation? If they're seeing that that's in special sections 11, and I understand that it's between buyer and seller, but if they're in agreement with what they're reading in special sections 11, it becomes part of the contract, correct?
You can't obligate parties outside the contract to the contract. So, I mean, it depends on whether you're accepting an offer that's been made or if you're trying to obligate the seller to make an offer as part of the contract. Those are two different things.
But you could also reiterate an offer that was made and accept it by saying seller agrees to pay X amount to buyer's agent or to buyer to compensate their agent, or however you want to phrase it that way. So then the language is for the parties within the contract, but it still is memorializing that specific amount.
Because I currently do that, I'll say, you know, the agency accepts the MLS offering of 2.5% from seller at time of closing. So I just want to make sure and wondering how that conversation, you know, can still be implemented. Thank you for that clarification.
You could also do it as a separate document between the brokerages saying, I'm accepting.
We have a
your
cooperation
offer. Yeah.
agreement in our forms library today that's as valid as it ever was, and it essentially is a memorialization of an agreement to cooperate. It can be for a period of time or it can be property specific, and you can memorialize that offering that way. It's a little cumbersome, but you could do it.
yeah, but the litigation is about problems with buyers and sellers understanding compensation, right? So yes, we have ways to legislate between the buyer and the seller in the contract, but I mean, the idea is you as a broker have to be able to prove that you entered into a knowing agreement with these people outlining the compensation. Relying on the contract to back that up doesn't feel as solid to me as having a separate agreement.
I guess it just feels transparent as well. Because like I'm very transparent when I go over documents with clients, and I just feel like having it between the buyer and seller also in special sections.
Also, but not instead of.
Exactly.
Okay, okay, sorry.
Yep.
Becky.
So that actually brought up a question I've been thinking of the past few days. When I look at the facts that realtor, it seems to me that both of these scenarios would be allowed. That an ERM says listing brokerage, you know, accepts or charges X amount, and this percentage of that would go to a buyer's agent the way we have it right now. It's at first I didn't think the settlement allowed for that, but I've seen that kind of clarify that you can have the listing brokerage pay. But you also could have an ERM that just had an amount for a listing brokerage, and then you could have a conversation that the seller, you know, is open to paying the buyer's agent as part of an offer or contract.
Well, remember that our administrative rules require, there's two requirements on any seller service agreement. You have to say if and how you're going to compensate a broker's agent, and you have to say if and how you're going to compensate and cooperate with an agent representing the buyer. So that's currently on page 2 of the exclusive right to market. Maybe that'll move, I don't know, we'll see. But you know, Vermont law still requires that discussion with the seller. So if you're seeing the zeros out there now, that means that in theory that the seller's agent and the seller are having discussions about not doing that and what the benefits and detriments of doing that is. But you can do both of your scenarios.
So the seller still could think like, oh yeah, I would, you know, be open to and being able to an offer with, you know, a certain percentage. But when I'm as a buyer's agent calling that listing agent to kind of clarify, is that something I need to clarify? Like, is this something that's in your ERM that there's like that cooperation between brokerages, or is your seller just suggesting that they're open to that.
It'll be in the ERM, and if you remember one of Chuck's slides, we're required to have the conversation with the seller about if and how and what it is that we're going to offer out to buyer's agents. That has to be had with the seller. Used to be, prior to the settlement agreement, you could share, Vermont law allows you to share your compensation without your client's permission. That will change.
Some of what we're seeing, I think what Becky's talking about, is we're seeing some 0% offerings to buyer's agents in the MLS, and then in the non-public remarks it will say, but the seller is open to potentially paying a commission. Yep. That's all okay. No reason it's not.
Yeah, so the seller can always say in their contract with you as their listing broker, say we're not offering anything. That doesn't ever foreclose a buyer from making the ask, right? And then when that contract gets in front of the seller, they have the opportunity to say yes, no, or maybe somewhere in between. It can be that negotiation. But I think one of the things to remember as we're having these conversations is that we're going to be talking about compensation with our buyers and sellers in a much more robust manner at many more points throughout the transaction than we do now. That, we're going to be hopefully having those more robust conversations at the inception of our relationship, but then it could come up again when we get inquiries from cooperating brokers, and it's going to come up again when we get offers that may be different from what we've discussed previously. So we have to get comfortable talking about money. Like Lisa said, it's not a comfortable topic, but it's really going to be a much more prevalent conversation we're going to have.
And remember, even at the sellers, there's certain duties that cannot be, that you can't give away under Vermont law. So one of the duties you can, even at your client's request, that you can't give away is the presentation of all offers, written or verbal. So if a seller says to you, don't bring me any offers that include a seller concession or that include I'm sorry, Mr. Seller, that is a duty that I am not allowed to, I can't do that. That's not lawful direction. Vermont law requires me to present to you every offer, written or verbal, whether it's at or above asking price. We're gonna be having this conversation, and you're likely gonna see offers that include compensation in them. That's just the landscape.
Something came on off that Prime MLS board meeting, and I just want to clarify that it's not necessarily a buyer's broker that you have to sign with the buyer when you go show them the house, okay? It's simply it's an understanding on how you are going to be compensated. So if you were working as a broker's agent, your agreement with them is, I'm going to call, and if there's a broker's agent, compensation for it, I can go show you this house. Otherwise, I'm not going to do that. I don't believe you have to sign a buyer's agency before you go show a home.
So I would, if I'm understanding that right, I would take task to that, because Vermont, the administrative rules and the statute only allow for 3 types of buyer brokerage agreements. So if you're going to represent a buyer as a client, it has to meet one of those 3, and it has to have all the elements required under the buyer brokerage things. If you're going to be representing them as a customer and they are not paying you, you are not required to do anything but provide them with mandatory consumer disclosure. In the face of transparency, I would be more transparent with an unrepresented buyer to cover my butt and say, so we are clear, you're a customer, I am being offered compensation by the listing brokerage to bring a ready, willing, and able buyer, but I do not represent you. And then if they decide after that showing to swap sides of the fence and move over to wanting a client relationship, both your code of ethics and the Prime MLS rules require notification to the listing brokerage that you are swapping teams, right?
Better than what I was trying to say, but exactly what I was trying to say is that you're not forced into a buyer's agency agreement to show it, but you still need to disclose how you're going to be compensated as a broker's agent.
Bingo.
So to follow up, just as an advocate here, if we knew we were taking a chance and not going to be compensated by showing a house because there's no offering at all, can we show the property to the customer?
Sure.
And we just say, I don't take my chances, and if they switch later to become a client, then that's great.
I mean, if it were me, I would be working with my broker to talk about all the different unique ways to date and not get married. If you're worried about, I mean, I don't cross, so this is just me. I've been doing it for 23 years. I do not cross threshold with customers. I just don't do it because it's risky, it's dangerous, and they have diarrhea of the mouth. So if they're worried about getting married, and I'm worried about getting married if I haven't met them yet, I'll do a one-day buyer broker, do a one-property buyer broker, do whatever. If you want your compensation to be zero, make your compensation. I mean, you can, if you're practicing in the confines of the administrative rules and the settlement requirements, you can get as creative as you want with your broker's permission and build the relationship and then change it from there. It's okay.
Yeah, I'd just add as an old plaintiff's counsel that, if you're going to show properties, but you really don't have the agreement, and then it relates back and it says, say the first house you showed, what a shock, is the one they actually liked. Not so that you get your buyer broker or your buyer agent agreement signed at such a point in time that consumer comes back and says, I was forced to sign this, or else I wasn't going to get to see this house again. You sort of have to think about who is my worst possible customer.
Yeah.
And that's, and that's the person I got to be sure I have all my bases covered with, not so they go back and say, well, I was coerced to sign this, because otherwise I would have no chance to buy this, the home of my dreams. And especially if the whole deal craters, then they're going to chase after everybody.
I mean, if I could just follow up on that, I mean, in some respects, I don't know if this is like the opposite way of thinking, but when you're meeting with the buyer, I mean, I think, tell me if I'm completely out of left field here, but like if you approach the whole situation as, hey, you're a customer, I don't represent you, I'm willing to show you one or two houses. And I understand we don't have a financial relationship. Don't tell me if Aunt Sally's giving you money, but let's see if we like each other. Let's see if you like my style. I'll see if I learn a little bit. Let's see if we fit. And then I'm going to ask you if we both agree that we can enter a relationship and we can discuss all those options. But then I know, hey, I might be showing two houses in Colchester where I'm not getting paid. They may go to somebody else. But it's almost like a mutual interview where and there's still nothing wrong with that as long as there's no financial. And then I'm like, I'm going to make sure you're pre-approved. I'm going to make sure you've got all these things. But will I give you an hour of my time to make sure that we like each other? Sure, but just know that I'm interviewing you as much as you're interviewing me. And I mean, I've been doing it a little bit with all this stuff. And I think it just sets a tone for their I'm not going to, don't tell me about any money, but let's see. It's hard to sign the first day that you meet someone. But now I'm like, you earn my time. And then I'll take care of you and I'll put you first when the house in Colchester that you love comes on the market. And then when they enter, it's like, okay, let's talk about all the things that involve around a relationship. And I find that has set a tone pretty well, because it's hard to ask people to sign before they even know you have a great dog.
I think that just goes back to Dora's point, which is if you're willing to take the risk of not getting compensated in order to go on that first date, then go for it. Sometimes people would rather just at least get them under a buyer broker so they can be a client just for that day. It's a personal both are okay.
Right.
Both are okay. Yeah. It's that transparency.
Within, that's still perfectly legal, ethical. Okay.
Well, and I think, an analogy of that is for attorneys. Sure, someone comes, they have a problem, they come see and talk to, one of us for an hour. Here's my problem, we hear their story, we tell them what we think we would do. They may retain us or not retain us. Right. Now, we're conflicted out about representing against them, but on the other hand, we're not going to make an appearance in court until you've signed that retention agreement. So it's like, up till this point in time, but I'll spend an hour of my time hearing your story, and I'll tell you my story, and see whether or not you want to work with me or if you want to go someplace else.
Yes, back there.
When you're presenting an offer to the seller and you're seeking some compensation, who is asking for that compensation? The buyer or the buyer's agent?
The buyer.
The buyer.
The contract's between the buyer and the seller. So if you're asking for something that hasn't been already offered, you're essentially asking the seller to take into consideration a contingency or a concession. That's a condition of the offer.
Right, so that has to be, you can't just verbally say that over the phone to the listing agent. That must be part of the offer.
Because it's really only the seller client that can, unless the broker is sharing their commission You're talking about the seller's, ability to give that money.
The piece that I heard the most questions about at our brokerage today was the amount of compensation must be objectively ascertainable and not open-ended. Buyer broker compensation you can't write into your buyer broker that it'll be whatever the seller is offering to the buyer. So there was a lot of questions about what can we write into section 3 of the buyer broker and how do we write it? And I am not clear on that still. So some people wanted to know, can we do a high and a low? Can we say, we'll accept 3% if it's offered out by the seller. I will accept from you as the buyer 1.5%.
Calculatable, it's ascertainable, it's clear. What you can't do is just say, I'll take whatever the seller's brokerage is offering, because that's not ascertainable. It also could be, we used an example in the last session, if I bought a home between 0 and 500,000, here's my fee. 500 to this, here's my fee. I mean, there's all sorts of different ways. But remember that if the compensation exceeds the amount agreed to in the brokerage service agreement, you have to have a conversation with your buyer client at the time of the offer. But when they're getting ready to write that puppy, what are you going to do with that excess amount? Because you're not allowed to keep it. So if there's back in the day, we used to have sellers would offer buyer agent bonuses. Bring me an offer before December 13th, and there's a $2,000 bonus. Well, if that $2,000 bonus exceeds what you agreed to with your buyer, you need to have that conversation. But you also need to have the conversation, hey, there's $2,000 coming into the pipe that neutralizes your obligation to me, or a part of your obligation to me. So it's meant to be, as Kate keeps saying, transparent.
Keep having that conversation. And, I don't think we touched on it yet in this session, but it came up a bunch at the earlier session, is that nothing in this prohibits you from collecting compensation from multiple sources to make that number that's in your agreement, right? So you can have a portion paid by the listing broker that's offered. You can have a portion that's paid by a seller. You can also have a portion that's offered by the buyer to equal that number that's in your agreement. You just can't go over that. And as long as it's clear where all of those funds are coming from, that's where that transparency comes in. It's totally fine for it to come from those multiple locations. It doesn't have to all come from the same pot.
And it can always be renegotiated.
Of course.
Remember, you could be literally finding them their house of their dreams and the numbers don't work. And you can sit down with your client and go, all right, let's figure out how to make this work. I'm willing to take a cut, or I'm willing to do something. It's a conversation. But the key is the client has to be part of it, and it's got to be transparent and clear. They can't be guesswork. It can't be, the broker outside in the parking lot getting their bonus check.
Conflicting counsel that some of our agents got, and I don't know where from, was that no contract can be dependent on another contract. So the issue there was you can't say, I'll accept 1.5% if they're not offering out 2.5%, because we don't know what the offering is. Thoughts on that?
Can't you just say a minimum?
Yeah, in that language that you've just used, that sounds like a slippery slope to me.
So that's my question.
Yeah.
Language that says I will accept a 3% commission. If the offering is less than 3%, down to 1.5%, I will accept that. If it is lower than 1.5%, you have to make up the difference between 0 and 1.5.
But you just say at least, I would accept at least.
I think
no, you don't want it. You don't want at least language. I think at least gets into that murky area because it's not really ascertainable, right? Because at least could be anywhere from here to $1 trillion, right? I think you. I think
X. It's X, or it's X times X.
We got into this trouble because of transparency. I think that a best practice, not necessarily what's required under here, but a best practice is to say, this is my fee. You can have a conversation with your client, and depending on what's offered and what the property is and if they love it, at that point then you can have a conversation saying, well, I'm willing to lower my fee to here. But I don't think you necessarily need to write into your contract that in certain circumstances I may be willing to lower it to here, because then you run into a potential plaintiff's attorney that could say, well, why didn't they get the benefit of this lower amount here? So I would say include in your contract what your brokerage policy is, what's your fee that you collect, and then if you need to amend it depending on the property that comes into play that buyer wants, then you can always do it at that point and you can have that conversation, but you're not selling yourself short or your services short, because, you know, it's sort of like the conversation we had with escalation clauses, right? That there's pros and cons to it, but you're showing your whole hand when you're saying, you know, I'm willing to pay this amount or I'm willing to accept this amount. So you could end up finding yourself in a difficult situation with clients saying, well, if you're willing to accept the lower amount, why am I signing for a higher amount that I might be obligated for?
Remember, your exclusive right to represent buyer agreement already has language in there about the ability of a broker's offering of compensation being able to offset the buyer's obligation to you. So that may change a little bit when it goes through the grinder, but that's already been in our agreements for years, right? I mean, that's how it's always worked. I'm going to charge you X, and X can be offset by the seller or buyer or seller's agent's offering of compensation. We've been dealing with this forever.
So we have a hard stop at 3, but in the bios, you have all of our emails, contacts, and obviously this conversation is going to continue. I want to thank our panel and maybe have them each put out their one takeaway from this that you want everyone to embrace.
It's all going to be okay. And you guys are here in Vermont, we're in a very lucky position compared to a lot of your colleagues in other states that, you know, using buyer agreements is entirely foreign and it feels like the sky is falling. And here, you're already comfortable. You already know how to have those conversations with buyers. You already are comfortable with your value proposition and having those conversations and being able to explain why you're worth the fee that you're choosing. So take away that little sliver of sunshine that, you know, it's all good. Sunshine, hope. I stole your hope.
Yeah, my final comment would be, don't move to another state.